Okay, Mr. Crawford, Ms. Augustin, how are you? Ms. Augustin, yeah, okay, you're unmuted now, but you'll probably want to mute it again shortly. But
Yeah.
Okay, so we are here for Dema versus Manu, and Mr. Crawford, are you going to reserve 5 minutes?
I will, Your Honor.
Okay, we're ready whenever you are.
Good morning, Your Honors. May it please the court, my name is Andrew Crawford. I'm appearing on behalf of Ms. Polly Dema, a public school teacher for 34 years with no prior criminal record whatsoever. Your Honor, this is an appeal from a final judgment for protection against stalking that was entered by a trial court in Pinellas County, Florida. Specifically, I've raised two issues in this particular case. I'd like to address the first one, which I think is the most pressing, which is the evidentiary sufficiency, which the courts have recognized is reviewed by the de novo standard. In this particular case, there is an allegation at a condominium complex in St. Petersburg, Florida. The appellee is on the condo board. My client, Ms. Dema, is a resident in the condominium complex. Ms. Dema was concerned about some of the things that were taking place. She sent a single email to the appellee in this particular case as it related to the condo board. In response, the appellee went to her house late at night, banged on her door, confronted her about the email that she sent to the board. Ms. Dema invited her in. Ms. Manu decided she didn't want to go into the condo. So at that particular point, Ms. Dema, fearing for her safety, said that she would defend herself. Ms. Manu left, and then Ms. Dema sent two emails to the board. After which time, this is in March of 2019, after which time the evidence reveals that Ms. Manu had actually called Ms. Dema, invited her to participate in some of the condo board activities. And then when Ms. Dema was assigned and did agree on behalf of the board to install or help install some cable equipment by Spectrum, there was a condo meeting in May of 2019. From the record, it appears that there was some dispute during the condo meeting. According to Ms. Manu, Ms. Dema mentioned that she would stand her ground and would defend herself. This is the second allegation. What's telling here, and which was attached to the petitioner's petition itself, which came in and which the judge considered, was a police report from the St. Petersburg Police Department. And this is found on page 18 and 19 of the record before your honors. What is extremely telling is that the police officer who investigated made a specific note that in these emails, which were the basis for the petition, there was absolutely no direct threats made to Ms. Manu.
Mr. Crawford? Mr. Crawford?
Yes, ma'am.
Police officer testify?
The police officer did not testify.
So what weight was the court, what weight does the law say that the trial court is to give that evidence?
Well, if your honor is getting to a hearsay objection, any hearsay objection is waived by the fact that it was attached to the petitioner's petition, which was specifically considered by the trial court. She read the petition. She made note of the police report. The petitioner made note of the police report. Any argument that there's some type of evidentiary objection to the police report is completely waived by attaching it to the petition. The door was wide open.
And Mr. Crawford, here, both the petitioner and the respondent testified, and the court had each of them before the court at that time to assess their demeanor, to assess their credibility, correct? And so we have to defer to the trial court as far as credibility and which witness they believed over one another, because clearly both of these individuals had conflicting stories. Is that right?
There were some conflicting stories, Your Honor, but regardless of the credibility, one way or another, even if you believe everything that Ms. Manu said, everything that she said, that is still insufficient under Florida law to issue an injunction for protection against stalking, according to the detailed case law that I cited to the court.
Okay. And how is that so? Because here we have, we have an incident that happens a year prior, and then it seems to be that the acts are escalating to the point where we have the altercation, as the petitioner lays out, that happened right before she filed the petition. Correct? It was something in the garage, and there's two allegations: the petitioner's allegations and the respondents. And the trial court clearly here leaned towards the respondent as to what happened, where leaned towards the petitioner as to what happened, where the respondent, I guess, blocks the petitioner in the garage. Correct? And I guess there's some profanities or whatever that are said.
That's correct. That was the allegations below. And let's, for
well,
the sake
Mr.
of
Crawford,
argument,
before you move off that, in that meeting that Judge Smith has just described, in my view of reading that testimony, there's a thinly veiled threat to use a weapon. Why don't you address that?
Certainly.
Because that's how I read it. So tell me, I mean, was there a thinly veiled threat to use a weapon or not?
I don't believe that there was, but let's assume for the sake of argument that there was.
Well, okay, let's talk about what she said. She said, "You better be afraid of me." Right? This is coming from a person who said they're going to stand their ground and that they have a gun. And so she says, "You better be afraid of me." So tell us how that is not a threat.
Well, the question is whether it rises to the level of stalking. And Florida courts, as I've cited throughout the initial brief and reply brief, say that mentioning a weapon without some type of overt act is insufficient on its face.
But in the garage where she stands right in where the testimony from the petitioner is, that she's standing in front of her, blocking her. Do we not now have the overt act along with the threat?
Not based on the case law that I've cited. And I'll specifically cite, Your Honor, to Banks versus McFarland, which is 148 Southern 3rd. That's a situation where you had a temporary injunction and the court found it was insufficient. And that particular case, the individual specifically said, "I'm going to shoot and kill all of you," yelled obscenities, "I'm going to F you up," without using the word, and made ugly remarks. That was insufficient. We don't even have that.
It was one incident, right?
It was one
a single incident, as opposed to a willful, malicious, and targeted following, harassing, or cyber stalking of another person as a statute requires. So the problem in that incident, it was one incident. We have more than one incident here.
Well, we also have Corey versus Cool, Your Honor, which is 160 Southern 3rd 97. In that particular case, there was a threat. The person chased the other individual and made a statement that she's got one in the chamber and 8 more in the clip.
Well, that's all one incident again, isn't it?
No, it's not.
It happened over a series of different times?
Yes, absolutely it did. You also have Shannon.
What was the rationale of the case then? Not that there was not a course of conduct, but that one incident you're speaking of did not constitute
the whole number of incidents did not support the issuance of an injunction, and they specifically referenced stalking and harassment in that particular case. That's from the 1st District Court of Appeal. The other one that we have is another one, which is Shannon versus Smith, which I cite in detail, which is 278 Southern 3rd 173. In that, there's multiple emails. There's actually an email to a person's boss. Someone is chased. There's an email that's threatening the individual. And there was a verbal altercation at an HOA, and that was still insufficient to grant an injunction for protection against stalking. Also, one of the things we haven't discussed here is stalking is a repeated course of conduct directed at a particular person, which causes substantial emotional distress and serves no legitimate purpose. Now, I cited in supplemental authority, as well as in the initial brief, substantial emotional distress is substantial. It is not just greater than regular distress. It's not, the courts have said it is not easily given, and it causes stress of a great proportion. And it's based on the reasonable person standard, not on what Miss Manu perceived, but what a reasonable person in her position would have considered. I respectfully submit that this was not demonstrated.
Let me ask you this. So let's say that we disagree with you that blocking someone's path in a parking garage and telling that person that they should be afraid and mentioning a gun and standing his or her ground doesn't cause substantial emotional distress. Let's say that we believe that one incident would. Isn't under the statute, it's the course of conduct that has to cause substantial emotional distress? In other words, if what the respondent said at the HOA meeting itself would not quite have been something to cause substantial distress, but coupled with the incident in the garage, doesn't that meet the definition of the standard of harassed, which is the course of conduct causes substantial emotional distress?
No, it does not. It does not meet the standard for stalking. Correct, Judge Atkinson, you are to consider the totality of everything that particularly happened in this case. But non-threatening emails concerning a condo board, which under Chapter 718, the condo board specifically represents the people in the condominium. When these are emails directed to the board, not necessarily a particular person, as is required by the statute. Furthermore, when it has to do with a legitimate purpose, you cannot consider that for the purposes of stalking. Furthermore, saying that you're going to defend yourself in your own place of, yes, Your Honor.
Okay, so what is the legitimate purpose in the board meeting in May where she's talking, where the respondent is saying, that's right, I'll protect myself, I have a gun? I mean, what legitimate purpose was that?
Your Honor, she was saying that she was being threatened in her home, and there was some argument during this particular association meeting. Saying that you're going to defend yourself is quite a bit different than saying you're going to shoot or kill somebody. Saying that you're allowed to defend yourself in your home is something that each one of us have a right to do.
Well, I think this is somewhat in the transcript with the court. The court has some discussions with her that the respondent's idea of what stand your ground means may be a little bit different than what the law is. So the court has that discussion. And so if she's using this for not legitimate means, can you then not agree then that how somebody, that this could rise to the level of stalking?
No.
Based on the facts that happened here?
Absolutely not. According to the case law that's been cited in my brief and throughout the reply brief, the evidence that was presented, non-threatening emails addressed to the board, one incident where where my client feels threatened and says that she's going to defend herself in her own home, and a public service announcement at a condo board meeting that she would defend herself is insufficient on its face to grant an injunction or even a temporary injunction, which was not even issued in this particular case.
You cite to Shannon as something being like there were a number of instances in that case, and this case doesn't even rise to the level of Shannon. And Shannon, was there any overt action in that case?
Yes, there was. Absolutely, there was.
Overt action. The
overt action in that particular case was the appellant had allegedly chased the appellee down the street on his bike. He or she had also sent emails saying a number of things, which I won't repeat, and an email to.
And when the chasing, what was happening? I'm trying to get the combination because you mentioned that the law provides that there has to be not just some emails and some text messages that are threatening. And you're correct in saying that in addition to that, there has to be some sort of overt action. Here, we have an overt action and we have a threatening statement. Do we have that same scenario in the case that you cite in Shannon, other than someone chasing someone on a bike?
Not necessarily so much in Shannon. In Corey versus Cool, you absolutely do. You also have that in Kimple versus Gagliano, which is 197 Southern 3rd 1283, and Banks versus McFarland. You know, and I think it's a crucial thing for the court to know that saying you're going to defend yourself in your own home is quite a different scenario than saying you're going to shoot somebody or going to kill somebody or anything of that nature.
You wanted to invoke the specifics of the stand your ground law. Doesn't the stand your ground law apply outside one's home?
It does. Absolutely, it does.
You're into your rebuttal time, Mr. Crawford, just so you know. It's your time. Use it however you want.
I'd reserve the balance, and I'd ask the court to reverse.
Okay. Ms. Augustin, we're ready whenever you are.
Thank you, Your Honor. May it please the court, Attorney Vanette Augustine for Appellee Besda Manu. I do want to first start by addressing the sufficiency of the evidence since we started with that. So the actions are being explored differently. So when we look at these three continuous actions, so we have one action of an email being sent to a condo board. There's no legitimate purpose behind an email saying, if she comes near my door again, I'm going to stand my ground. The stand the ground statute simply says, I have a weapon and I can use that weapon. And so the second act, which Attorney Crawford talks about with the meeting, the condo meeting that took place, and she was just making a public service announcement. That was not the case. The situation that arose at the meeting was there were volunteers that were getting ready to go into different individuals' apartments. The Ms. Dema volunteered to go into my client's apartment to be there for inspection purposes. My client at the meeting says, I'm not comfortable with that. She's threatened me with stand my ground before. And so I'm afraid what will happen if I go into the home and she feels threatened and she will kill me in my own home. So that was the statement that was made. And Ms. Dema's response to that was, darn right, I'm gonna stand my ground if you come near me. So the statement wasn't, I'm going to protect myself in my home. It's, I'm volunteering to go into your home who I'm supposedly afraid of and I'm standing my ground against. But in that process, if you come into your home while I'm in there, I'm going to stand my ground. So that was the gist of that. It wasn't a public announcement that was made that she just randomly made a statement. My client did provide witness testimony who saw the aggressive behavior that was raised, who testified to that as well. And then the third, with the overt act of her literally blocking my client in a garage from going into the condo and letting her know, you better be afraid of me. When we look at the totality of the circumstances and condition, we don't have isolated incidences as opposing counsel is stating. We have continuous threatening acts that placed my client in a situation to where she was afraid for her life, and she took the steps to seek an injunction. Opposing counsel, go ahead.
I asked the appellant about the construction of the definition of harass, and it does seem as though the substantial emotional distress can be caused by not necessarily each instance of conduct, but the course of conduct. But under course of conduct, it has to evidence a continuity of purpose. So if there were some of the instances were themselves not threatening to a point where they're not directed towards your client in a way that was intended to be threatening, can you count those among, could you talk about whether those and how those could be counted in the course of conduct if this court were to decide some of them were not threats?
Are you asking me to determine if individually they would fit within the course?
Right. Should we discount them if there are some of them that were not threatening? That were that they might have involved your client, but they were not directed directly at her. Can they be counted in the course of conduct?
They can, because when we look at the only one that wasn't directed towards my client was the email that was sent to the condo. But the email that was sent to the condo, my client sits on the board. So there, she knew, she would have to have known that that email would have been shared with my client.
But it has to have a continuity of purpose. So that instance has to share the purpose that you're ascribing to the other instances, which is to threaten respondents.
Right. So to me, for my client, perceived that as an indirect threat to her, because ultimately the message would have gotten to her. She sits on the board and the board would have addressed it with her. So, and there's no legitimate purpose to send an email to the board to say, if this board member comes near my house, I'm going to stand my ground, knowing that that's going to be shared with her. So to me, all of that goes in line with the continuity of all of the events taking place to let her know, I have a gun, I'm going to stand my ground and I'm going to use it. And those were repeated threats that were made over and over again. So I don't believe that the court can, even if you were to take that one out, you still have the other two events of her wanting to go into the home to stand her ground into my client's home, and then blocking her into the garage and saying, you better be afraid of me. And so it's just, I don't see how you can exclude that. But even if you did exclude that one, it's harder to exclude the other two. I don't know if you had another question or if you.
No, I did not. No.
Okay, thank you. So that's when the trial court made the decision, the trial court looked at all of the totality of circumstances and stated that in the opinion that in light of all the circumstances, and the trial court went into and quoted the specific statute. Let me pull that. So the trial court quoted the specific statute that's in the ruling. I apologize. Let me find the ruling. I am so sorry. I thought I had it highlighted. Where the trial court specifically cited the statute and stated that based on the totality of circumstances, when you're looking at the text messages that was sent, when you're looking at, not the text messages, the emails that was sent, you look at the threats that was made in the garage and the threats that was made at the meeting, that does meet the burden. And that was quoted on the record, page 105 to 106. And so what a court specifically said, I find that based upon the testimony that has been presented, that the petitioner has met her burden of proof as it relates to stalking. So there's been a course of conduct that has been repeated and has served no legitimate purpose. And there was no testimony given by the opposing side to indicate that there was a legitimate purpose for her sending any of the emails or making comments at the meeting or blocking her into in the driveway or in the garage. And so the next thing I want to touch on briefly is whether or not her due process rights were violated. Opposing is making the argument that she was served 3 days prior. And so because she was served 3 days prior to the hearing, then she was not afforded due process to be able to.
She never objected though, did she?
Exactly.
Yeah,
and
she was there, she made a presentation, she went forward and she never said, by the way, I needed more time or I want to continue. And so none of that ever happened, right?
That is correct. And that is reflected in the trial court's decision on the rehearing when she specifically stated that she showed up with witnesses. She had 3 witnesses. She called one, she made an opening, she made a closing. At no point in time did she say, even in the opposing counsel's argument was that a lay person may not know to say, I want a continuance, but a lay person would know to say, I need more time. I need more time to prepare my case. She came in, she was well prepared, and that was made evident in the court's ruling. And the court specifically stated, she asked the parties, were they ready to go? Both parties said they were ready to go. Both laid out opening statements. She questioned her, she called her witnesses, she cross-examined. So due process was afforded. It wasn't a situation where we can now say, I now have 20 witnesses, let's redo this. The motion to continue was not preserved. And so I don't believe that that would be something that the court here can then take on when the party never raised it to begin with on the trial level.
Mr. Gustin, let me ask you a question. As a trial judge, I presided in many, 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 many injunction hearings. So I know what it's like firsthand to sit on these. And what troubles me as I read this case and prepared for today and have listened to you all argue is that I know that as sitting in the courtroom, as the judge in the courtroom with all the parties there and all the witnesses there, they are going to see and feel and perceive things that there's no way we on an appellate court can feel or perceive from a cold record. And what Mr. Crawford has argued, I think he said under no scenario do these facts meet the requirement to issue this injunction. They just simply, under the case law, and he cited some really good cases that have some pretty egregious facts beyond our facts, be honest. So he's made a very persuasive argument, but I know sitting there hearing this, the judge who made this decision was concerned enough to issue this injunction. And there may not be things in the record, that we can sort of perceive and feel that. So appellate courts have a tendency to be very slow to turn these over because they know that trial judge was in the room with these people. We are not. Help me address Mr. Crawford's cases that appear to have more egregious facts than ours, coupled with the observation I've just made. What are we to, we got to give deference to this trial judge who was there as opposed to us, right?
Right.
What do we do with these facts vis-a-vis his cases, which are pretty extreme factual scenarios where an injunction was not granted? What are we supposed to do with that?
Well, when I look, so there were several, I believe he cited over 40 different cases. And so when you look at the different cases that are cited, there's states, not a fact specific, right? So there were some, yes, egregious actions that were overturned, but what the courts were looking at in a lot of those cases was really, did the individual who was being threatened, did they exhibit any feelings of harm, any emotional distress? In a lot of those cases, the individual just didn't talk about that or didn't present that, or there was no evidence that showed that they felt that they were in imminent danger. So yes, threats can be made, but absent the emotional feeling that something is going to happen to me or I'm in imminent danger, that alone is not sufficient. So
what do we have in our record to make that point? What do we have in our record to show that your client absolutely was emotionally rattled by this whole thing?
We have her testimony, the testimony which she said in all three instances when she indicated the first time to the board, she said, I was afraid. When the email was sent, she testified that made her afraid. And
but are we supposed to, is it a subjective analysis or an objective?
No, it's not
analysis?
a subjective, it's objective. Okay. But one of her witnesses testified to being at the condominium association meeting, and in that meeting, heard the threats that was made, and he's saying he's being of military background, felt threatened as well. So it's not a subjective, it's what a reasonable person in that situation feel threatened. You have 3 incidences and one where you're being blocked in a garage and the person is saying, I'm going to kill you. But I think even the bigger part or the more scarier part for my client, and she expressed that at trial, was simply that she volunteered to go into her home for an inspection. And when she said, I don't want that, I'm afraid that if she comes into my home, something will happen. She then again at the board meeting says, yes, I will stand my ground. So I don't believe I think any reasonable person in that situation would look at that and say, that's a threat, that's someone coming into your home, invading your privacy. It's not someone standing outside or neighbors feuding in some of the cases that was raised by opposing counsel. This is someone coming into your home. So that I would say that that's not the same.
Thank you, Ms. Augustine.
What about the argument that was made that actions subsequent to some of the instances in the course of conduct undermined the petitioner's testimony that she was under substantial emotional distress? In other words, after one of the emails, she still encouraged involvement by the respondent in the HOA meetings and still, facilitated scenarios in which they would be physically present at the same time.
Well, she did not encourage involvement. The way the condominium board is, she could not block the tenant who is the opposing side from attending that meeting. So she expressed her concern to the board, but she has, as the board member, she has no authority of blocking stalking that. The only way she can do that is by seeking an injunction, and that's what she did.
Is that correct? Okay. It creates a factual issue that, like Judge Morris was explaining, is a matter on which we'd probably afford a lot of deference to find her fact. That was a rhetorical question. I think your answer would be yes.
Yes, Your Honor. So I would submit that the trial court, as the case law says, has broad discretion, and unless we find that there was an abuse of discretion, we should uphold the trial court's ruling that there was stalking in this particular situation, and also uphold the ruling of the trial court that the opposing side was afforded due process.
Okay.
Thank you, Your Honor.
Thank you very much. Mr. Crawford, 5 minutes.
Yes, Your Honors. First and foremost, the standard of review is de novo, not abuse of discretion. Second off,
would it be? I'll concede that and say, you know, perhaps discretion wasn't the word to use, but on the factual determinations, those are not reviewed de novo. Am I correct? So if there's a factual determination that the petitioner experienced substantial emotional distress, is that something that has a different standard of view than de novo, or is that
no, that is still de novo? I'd also point out,
is that because it's an objective test, or
it's an objective.
Why is it de novo?
It is de novo specifically because to determine whether there was sufficient evidence to grant a stalking injunction, the courts are required. That is a de novo review. One of the elements of stalking is substantial emotional distress, i.e., that would be, you know, the de novo standard of review. But more importantly, I can't overemphasize here that when law enforcement responded, and I understand what the court has said, there was no direct threats in any of these emails. These emails were not sent to any one specific person, especially during the May 2019 meeting. There was no exchange of words between the two. No one ever said, Ms. Dema never said anything directly to Ms. Manu during that condo board meeting or after the meeting. And in Ms. Manu's own words to the St. Petersburg police officer, this was more of a public service announcement, not directed to her. Now, that is completely in the record before your honors. That is not stalking. That is absolutely not stalking. In any definition of the word, is it stalking? Furthermore, the emails were, again, non-threatening in nature. These are non-threatening in nature emails, coupled with someone saying they have the right to defend themselves in their own home, is not a threat. That is just absolutely not a threat with any overt act in order for this court to uphold a stalking injunction, especially based on the case law that I've cited, which, as Judge Morris, you have noted, is much more egregious than what we have here. Now, your honors mentioned you're looking at a cold record, and I understand that. However, ask yourselves this question. If Miss Manu was so scared of the appellant in this particular case, why then at the end of the hearing did she specifically say that she wanted Miss Dema to attend these condo meetings? That was a direct question from the judge, who was going to exclude her from these meetings. Nevertheless, Miss Manu still wanted our client to attend. That is not substantial emotional distress within the statute, and it completely was not met in this particular.
Is it possible that she was less concerned about the respondent's presence at a meeting that was heavily populated than she would have been if she had encountered the respondent in a parking garage, for instance?
No. If she was so scared of if she was afraid of being shot, which is the whole crux of this case, she would not have agreed to that. No reasonable person who was in fear of being shot would agree to be in condo meetings that had previously been ruckus, according to the police officer's report. The other thing I would point out, and I'd ask this court to do, and I know I have a limited amount of time, if you are going to reverse this case and vacate the injunction, again, Ms. Dema is a 34-year public school teacher. I put this in a motion. She is coming up for renewal of her contract. She will lose her job and her income. And the reason I'm asking the court to do this is if you're going to write an opinion, please do it.
Mr. Crawford, is all this in our record
It is.
about losing her job and all that?
I did a motion to expedite, and that's what I'm asking the court to do.
Okay.
Additionally, Your Honors, based on the case law that I have cited, which is numerous, replete, from every single district court of appeal in the state of Florida with stalking injunctions involving neighbors, the evidence presented here is woefully insufficient to grant an injunction. Woefully insufficient, based on the precedent, the plain language of the statute, and what happened in this particular case. I'm respectfully asking this court to reverse and remand and vacate this injunction based on the arguments, the precedent, and the facts that were demonstrated below.
Okay. Thank you both very much. These are always difficult cases, quite frankly. There's always a lot at stake. And you both did a fine job in laying out the issues for us. Okay. We're going to take a 5-minute break. By my clock, it's 12:03. So to keep the math simple, we will start again at 12:08. Okay?
Thank you, Your Honor.
All right. Thank you.
Thank you.